3 bill hearings. The first one is Senate Bill 367. I'll open that hearing and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 367 requires officers to file copies of receipts with the court when property is seized under a search warrant, and it also provides requirements and procedures for destruction or disposition of dangerous drugs and the return or disposition of weapons. The bill amends KSA 222512, part of the Kansas Criminal Procedure Code that governs the custody and disposition of property seized by law enforcement under a search warrant or validly seized without a search warrant. Current law there in subsection A requires the officer seizing the property to safely keep the property until it's no longer required as evidence. This bill adds provisions that if criminal charges are not filed, the property would then have to be returned to its rightful owner or disposed of in accordance with this section. In addition, after the seizure of property pursuant to a search warrant, this officer who seized that property would be required to file a copy of the receipt describing the property with the magistrate who issued the search warrant. The bill also amends subsection B to add dangerous drugs to the requirements relating to disposal or destruction of hazardous materials seized after representative samples are preserved. And then it also defines both dangerous drugs and representative sample. The bill also adds requirements in subsection D1 for weapons that are seized to provide that if the weapon was stolen or seized from someone who's not the rightful owner, the law enforcement agency must notify the owner of the weapon that the owner can retrieve that weapon from the agency. If the weapon has been seized from a juvenile, the law enforcement agency would be required to notify the juvenile's parents or legal guardian that the weapon would be able to be retrieved. I would also note that this bill is substantially similar to a bill you guys heard in 2020. It was House Bill 2446. You heard that bill in this committee, but it died in committee and you didn't send it out of here. And I can take any questions.
Do we have any questions for Natalie? Taylor?
Thank you, Mr. Chair. I filed the receipt with the magistrate that issued the warrant. Typically, in my recollection, you filed it with the clerk of the district court where the file is for the warrant. Of course, everything is paperless now, right?
Mr. Chairman, I'm not sure if there would be the ability to file that physically or if that would be required to be e-filed. I'm not actually sure. Ed might know that. Okay, Ed knows that.
I said somewhere in here I thought that it could be e-filed, but does that file for the search warrant still remain sealed, or is it a public open record?
Well, are you talking about the receipt that once it was disclosed, or because we have a separate statute that
search warrants are issued while investigations are ongoing.
Mm-hmm.
And for somebody to be able to go and look to see whether or not some property was seized is something that's very significant. I just want to make sure that we're maintaining the fact that they are confidential.
Mr. Chairman, Representative Wheeler, I would have to, there's another statute that talks about what can and cannot be disclosed respective to a search warrant. We did make some changes to that, and it's been a number of years ago now, I guess, about the affidavit being able to be released. So I would have to go back and look to see. That is something Ed might also know off the top of his head. But
thank you very much, Nat.
Any other questions for Natalie? Representative Carmichael.
Thank you, Mr. Chair. Ms. Scott, I was not listening as carefully as I should. The 2020 bill was HB
2446.
I had it down wrong. Thank you for your assistance.
Okay, thank you, Natalie. We will start with proponents, and Ed Klump is here today. Whether you're here or not, Ed, I just assume now you're hiding behind Representative Owens every time I look up. So
I like my little corner.
I can't see you.
Good afternoon, committee. Mr. Chairman, my name is Ed Klump. I'm here representing the three associations I normally do: Kansas Sheriff's Association, Kansas Association Chiefs of Police, Kansas Peace Officers Association. I'll add a couple of pieces of information. 2020 House Bill 2446, as was noted by the revisor, died in committee. Remember 2020, that's when COVID killed this bill and many other bills and pretty much the session. So we just didn't get past the hearing on that. Also, Senate Bill 367, the one that is before you now, passed the Senate 40-0. So here's why we're here. We're trying to resolve several issues we've had with KSA 222512. And Representative Wheeler, before I forget, this bill does nothing to change current law on sealing search warrant records or disclosing them. So whatever the current law is, it will be if this bill passes. It doesn't change any of that. So the first thing in this bill is subsection A. Current law requires us to do two things when we seize property under current law. One is to give a receipt to the person that we take the property from. And the second one is to report that seizure and what we seize to the court. The problem we have is that second part, it doesn't distinguish between seizing property under a search warrant or seizing property not under a search warrant. And the courts don't want anything from us when we seize it without a search warrant because they don't have a case file to put it in. And so what this does is clarifies the practice that's been going on for years. And that is that we will continue giving receipts regardless of whether it's with or without a search warrant. We will continue to report back to the court along with a search warrant what the items were that we seized. However, we won't report to the court. We haven't been. The court doesn't want it when we seize items without a search warrant, but we still do the receipt and all that. So also in subsection A is another issue that Representative Wheeler asked about, and that's the electronic filing. And when we started this bill, when we were vetting it before the session, I was contacted by the courts and asked if we would put something in here that would allow electronic filing of this information. And so there is a provision in there that allows it. And I think the wording is something to the effect in a format acceptable to the court. So if the court wants it in electronic format, the law allows for it. It's not up to the law enforcement officer. It has to be what the court wants. And so that provision is also in there in subsection A. And then we come to subsection B, which Natalie described to you. What we would like to do there, there's already a provision when we have hazardous material that we're allowed to take adequate samples for both the prosecution and the defense. And then the remainder of it can be destroyed. So we're not housing a lot of hazardous materials. We'd like to add to that large quantities of drugs. So right now, especially with the fentanyl and the carfentanil, it doesn't take much of those in quantity to be very dangerous to have around, accidentally spill them or whatever. And we'd just like to have the same permission in the statute to deal with those the way we do hazardous material. It would still require us to maintain adequate samples for testing for both the defense and the prosecution. And of course, we would have to catalog the quantity of the items that we'd seized and destroyed. In subsection C, you'll see some amendments, but I believe those are all technical amendments by the reviser. And then in subsection D, we get to why we even started down this path with this statute, and that has to do with the return of weapons and firearms. In current law, what current law says is that if we have seized a firearm and we no longer need it, then we must check to see if it's stolen. If it is stolen, we give it back to the owner. If it's not stolen, we give it back to the person from whom we seized it. And the struggle that we were having several years ago, and we still have a few of these, but it's kind of slowed down because nobody was winning them, is we were getting slammed with quite a few cases where a prohibited person, prohibited from possessing a firearm, who we'd seized it from, came in and said, by God, the statute says you have to give it back to me. Well, of course, they'd file a court action. We'd have to go to court and defend it, and we'd always win it, but it was just a hassle. And so as we looked at this, we saw a lot of things in here that were kind of troubling from the aspect of getting property back to the owner when it comes to weapons. So what we propose in this is a 6-step process. Number one, if the firearm is stolen, it's returned to the owner. Now, sometimes the owner has changed because now an insurance company owns it, but we'd return it to the owner, whoever that is. The second one is new, and that is if we have knowledge the firearm is owned by a person other than who we took it from, we still give it back to the owner, not the person we took it from. So we assure that it goes back in the hands of the owner. So if I was to loan, well, let's turn this around. I'll be kind. If Representative Wheeler was to loan me his firearm and I'd go out and do something really stupid with it and the police would end up with it, under current law, they'd have to give it back to me, the guy that did something stupid with Representative Wheeler's firearm. And we want to be able to give it back to Representative Wheeler because his only deficiency in that was letting me use the gun. So the third one is if we seize it from a juvenile. We don't want to give it back to a juvenile. We want to give it back to a parent or guardian of the juvenile if they're the rightful owner of it. And then the fourth is we return it to the person from whom we seized it. So if you go down that pecking order and then we give it back to the person that seized it. And then we add a provision that if any of the above are prohibited by law from possessing the firearm, we're required to notify them that we believe they are prohibited. And then we're required to hold that gun for 60 days after giving that notice. And that's to give them time to file a court action challenging our assessment of the record that they're prohibited. So it gives them the due process to challenge our interpretation that they're prohibited. And then finally, the sixth thing is that there was a Supreme Court case, and I think it was back in the mid-90s, called Henderson versus U.S. And this came to light as we were discussing with other law enforcement parties leading up to your original bill in 2020. And what we learned is very few of our law enforcement agencies were aware of that case. And what that case said is the actions of a person in committing certain felonies or other things that lead to a prohibition under the law of possessing a firearm, you can take away that person's possessory rights to a firearm, but you cannot take away their ownership rights. They still have a right to the ownership and their investment, so to speak, in that firearm. And so what we wanted to do was put something in this bill to cover that, to assure that we abide by that court ruling. And so there is a provision in there that talks about how that takes place and how we deal with that if we have a person who is prohibited, that we can handle that in a manner that they're not in possession of that firearm, but they can still transfer it to another responsible party, or they can choose to sell it and we can transfer it to like a gun dealer or something like that to sell it for them. And so we have provisions in there for that. So that's what this bill does. That's what we're trying to clarify. We think this is a much cleaner process, especially on these weapons dispositions, to get it back to the rightful person. And Mr. Chairman, I'll stand for questions when it's appropriate.
Very good. We have at least one, Representative Humphreys.
Thank you, Mr. Chairman. So I just want to go back real quick. In section D, I think you said there were 4 possibilities of who the seized weapon would go back to, but I only got 3 of them and I can't find the 4th one. Did you say 4?
Well, there's 6 steps, but there's really 4 different groups of people,
Okay.
and 2 of them are the owner. Okay.
2 of them
So,
were the owner.
yeah. So one is if it's stolen, it goes back to the owner.
Okay.
That's number one.
Uh-huh.
And the second one is if it's not stolen, it still goes back to the owner if we know who the owner
Okay,
is.
that was
Yeah.
I didn't catch.
Okay.
And then how do you know who is the owner? If it's not the person who you took it from, how do you know who is the owner of the gun?
Usually the owner comes to us and tells us they own it. And we,
Just out of the blue, they've heard that this person, like
well,
Representative Wheeler heard you got in trouble, so he
right.
would,
And so now the police has his gun. So he goes down there and says, hey, I want you to know that's my gun. And that's usually how we become aware of it.
okay. Or if a gun is stolen, maybe the person has made a report. I mean, do you have access, like if it was in, Cowley County or something? I mean, and
But we have access, stolen firearms, when they're reported to us with a serial number, are entered in NCIC, and we'll, no matter where in the country it is, we'll get that hit. A stolen gun that we don't have the serial number may not, be as easy to find. But if we do learn of that, then we will notify that person who we believe is the owner of it, and work through that process with them for them to demonstrate they're the owner.
And just last thing, if they didn't come forward to say, hey, you've got my gun, then you would you have a way of knowing who the gun belonged to?
Not really, unless you just launch a whole investigation, which is very time consuming. When a gun's used in a crime, sometimes we'll go back to the original ATF data on when that weapon was sold, and then we'll start contacting people and, who'd you sell it to, who'd you sell it to, who'd you sell it to? And sometimes we run across a person that says, well, I didn't sell it, it was stolen, never reported it, but it was stolen. And then sometimes we get back to the person that it currently belongs
Okay,
to.
thank you.
Representative Wheeler.
Thank you, Mr. Chairman. It says, if the weapon is seized from a juvenile, the agency shall notify the parent or legal guardian of the juvenile so that they may retrieve it. If the weapon doesn't belong to the parent or the legal guardian, but was given to the kid by somebody else, what happens then?
Well, again, if we know who the owner is, that's the first in the list, and that's where it's going to go. If we don't know who the owner is, actually, this provision is kind of meant to work along with the next one, which is to give it back from the person we seized it from. So at that point, when we don't know who the owner is, we're going to give it back to the person we seized it from. This creates an exception for that when we seize it from a juvenile, that we don't give it back to the juvenile, we give it back to a parent or guardian.
Well, I'm not going to loan any kid my gun anymore. Thank you, sir.
Any other questions? Representative Carmichael.
Thank you, Mr. Chair. My recollection is that Sheriff Easter gave testimony perhaps in this committee earlier this year about the circumstance where he sees firearms that he's seen before. They may even have a case number identifier or something on them. They've been used in crimes before, and he was very upset, not very upset, but he expressed concern that weapons used in crime find their way back to the streets, and we see the same weapons, just like we see the same people over and over again. What happens with firearms where we can't identify a legitimate owner or responsible person? What happens with those weapons?
Well, the only way that's going to happen is if we find an abandoned gun. Otherwise, we've seized it from a person, maybe a criminal, maybe somebody else, but for some reason we seized it from a person. But if we seize a firearm or take it into our custody that isn't from a person, then, we have methods to try to establish who the owner is, but it goes just like any other piece of property. It's going to be sold under current law.
Well, let me give you, with the chair's permission, a different example. Let's say that someone owns the weapon and they use it to hold up the local stop and rob store, and they can't possess the weapon because they're going to be convicted. Then are you saying you sell their weapon for them or get it to an FFL and they then get the proceeds from the what happens with those?
That goes back to the Henderson case, and what the Henderson case says is they have an ownership right in it. We can't dictate to the owner what they do with their ownership right, but we can facilitate them doing something with it. And that's in essence what Henderson said. So that we can, for example, Henderson went into great detail in giving it to a third party for safekeeping, talking about the risk if that person's going to give it back and vetting that. So that's one option, though, that is available if it's vetted well. And then the other one is the person wants us to transfer it to like a licensed firearm dealer that's either going to store it or sell it for them or whatever. But we're not going to sell that at that point. because they have that ownership right to it.
But under the statutory scheme, we are not, and I don't want people to get upset, we're not taking weapons that are used in commission of violent felonies that are owned by the criminal and grinding them up. We're one way or another, we're putting them back out on the street under this scheme.
Under current law, this was passed, I don't know, 3, 4, 5 years ago. Prior to that, it was at the option of the law enforcement agency. They either destroyed them or they could sell them. After another group of things they can do with them, like they could convert it to their own use. They could give it to one of the forensic labs. They could give it to wildlife and parks. There was numerous things that you could go through in that. But the law now is that we cannot destroy any firearm unless it was used in a homicide or a voluntary manslaughter case. And in those cases, we can destroy it. The only other exception is if the firearm is not functional and has no legitimate value as a firearm, then we can destroy it.
Altered serial numbers.
Altered serial numbers, I think, would fall under that too. I'm not sure if that's spelled out in the statute. I'd have to look.
Thank you very much.
Any other questions? Okay, thank you, Ed. We have written proponent testimony from the League and the Kansas Highway Patrol. Any other proponents? Are any neutral conferees? We have one opponent listed, and he's online, Nick Reinecker.
Thank you, Mr. Chairman. Can you hear me okay?
Yes.
Thank you, Mr. Chairman and members of the committee for allowing me to speak today. My name is Nick Reinecker from Inman, Kansas. I'm an opponent to this bill for one reason. Dangerous drugs is defined on page 2, lines 11 through 13. Does not include such things as alcohol, aspirin, or cough syrups, including those with dextromethorphan. Knowing that the lethal dose of these substances is far less than cannabis could ever be, if at all, my only opposition to this bill could be subsidized or subsided by changing the word dangerous to controlled or illegal. I looked up the word dangerous on Google here just a second ago, and the definition says it's able to, or likely to cause harm. So I guess if we're going by these definitions, then legal drugs such as alcohol, aspirin, and cough syrups must be like BB guns. Cocaine on Schedule 2 must be like a 20 gauge, and cannabis, since it's on Schedule 1, must be those dangerous assault drugs that we hear so much about. But with all jokes aside, just changing the word dangerous to controlled illegal or illegal would help me to be in support of this bill. Thank you, and I will stand for any questions.
Any questions for Nick? Okay, thank you. Any other opponents? Closing the hearing on Senate Bill 367, opening the hearing on Senate Bill 434, and invite Natalie back up.
Thank you, Mr. Chairman. Senate Bill 434 would create exemptions in the Open Record Act for records that contained captured license plate data or that pertain to the location of an automated license plate recognition system. Section 1 amends KSA 45217. That's the definition section in the Open Records Act. Subsection A defines an automated license plate recognition system as one or more high-speed cameras combined with computer algorithms used to convert images of license plates into computer-readable data. And then subsection C would define captured license plate data as the global positioning device coordinates, date and time, photograph, license plate number, and any other data captured by or derived from one of those automated license plate recognition systems. Section 2 amends KSA 45220. That's the Open Records Act statute concerning the procedures for obtaining access to or copies of open records. The bill adds a new subsection J to provide that a request for records that contain captured license plate data or that pertain to the location of an automated license plate recognition system submitted to a state or local law enforcement agency or governmental agency shall be directed to the state or local law enforcement agency or governmental agency that owns, leases, or contracts for the automated license plate recognition system. And then finally, section 3 amends KSA 45221. That is the statute in the Open Records Act that provides the discretionary exemptions. This bill adds a new subsection A55 to provide that a public agency is not required to disclose records that contain captured license plate data or that pertain to the location of one of those automated license plate recognition systems. And I can take any questions.
Questions for Natalie? Thank you, Natalie. Begin with proponents, and Ed is back up.
Thank you, Mr. Chairman, committee members. Ed Klump, Kansas Association Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. We brought this bill to address an issue that has been recognized by law enforcement agencies and also by Department of Transportation. And that is that the records of the data collected by these license plate readers had no clear protection under the Open Records Act, which meant that there was certainly a possibility that people could come in, make open records requests, and try to get data on any individual they wanted to see where we might have captured their location at. We didn't think that was appropriate, so what we're trying to do in this bill is create a balance between what you're going to hear is the extremely valuable tool these are in solving crimes and the right of privacy of the people. Two things I want to note on that is that this bill does nothing to close these records from access through a court order if a person has a civil case or a criminal case where they need information to support their position, whether it's prosecution or defense. And this bill does nothing to close the public records, such as the purchase of these devices or those types of just the business transactions of the government entities that are buying them. So as a result of this recognition that there was no core exemption for this and no protection from the Open Records Act for these people's activities and data, KDOT had advised us informally several years back that they were not going to allow us to place these devices on state and federal highways any longer. And of course, that's one of the areas where we'd like to be able to use them. And so we worked with them over the interim in trying to address this, and this was identified as the reason that they had come to that conclusion. And so we want to try to fix that at the same time we're trying to protect people's rights, their privacy rights. So under this bill, the data would be closed to open records requests, and so would the location information. That's because we want to protect where these are so people don't just circumvent them. And you're going to hear from some of the other proponents some of the data on the cases they've been able to solve and the property that's been recovered and things like that through the use of these. Because I want you to see at the end of the testimony the balance that's there between the value of these tools and the privacy rights. These, modern criminals use technology to commit their crimes. And if we're going to keep up with that, we need to be able to use technology to try to protect victims and solve crimes. And that's what these tools do for us. So again, it only protects the distribution of the data and the location of the systems. The location information should remain protected to avoid the location information being used to allow criminals to divert away from them. and it does not close records dealing with costs, purchases, processes, or other related information public should still have access to, nor does it close it to discovery through court orders or discovery motions. And I'll end there, Mr. Chairman. I'll answer questions when appropriate, but I'll let the others speak about some of the valuable results they get from these tools.
Yeah, let's move on. We'll do the other proponents, and then we'll come back in case maybe they answer some of the questions we have. So Lieutenant Slaughter is next, and he's online.
Hi there. Everybody can hear me okay?
Yes, we can.
Okay. Lieutenant Casey Slaughter, and I'm the Auto Theft Commander at Wichita Police Department. Thank you, Mr. Chairman and members of the committee for having me today. Just a little bit of background on our program. We started in 2014, so we've been running with a great license plate reader system and a model since then. We've grown our program from just a demo and one mobile system to 7 mobile systems and a fixed system. One of the things we really hang our hat on is our robust training program that we have for every single officer that is on the department and every single officer incoming to the department. We have a very strong policy that's gone through 3 reviews now and is considered to be a model for the rest of the nation. And that's according to the Houston HIDA LPR director, and the HIDA stands for High Intensity Drug Trafficking Area. And then we conduct random and directed audits aimed at ensuring that people are not misusing the data within the system. In drafting license plate reader legislation and trying to come up with what was something that was reasonable, we looked at 16 different states and what they were doing. We consulted 5 different chiefs of police and a sheriff, all of whom were using license plate data and license plate readers here in Kansas. So what brought us to this point is something that Ed Klump mentioned, and that is that on July 6th of 2020, we had already had a fixed license plate reader location that was up and running on a state highway here in Wichita, bordering Wichita and Goddard. We were looking to put up a second one, and we were going through the process, and suddenly Department of Transportation informed us we were no longer going to be permitted to do so for the following reasons. And that was that there were no laws restricting the use or availability of the data, and then who is responsible ultimately for maintaining that data. And I think that second part is a pretty easy and clear answer. It's going to be us, the agency that purchased and controls the data. Both of these fixed systems were purchased on a JAG grant, so federal JAG funds were used. And currently we have one sitting for almost 2 years on a shelf, and we can't put it up. Some of the stats I did want to talk about that Ed kind of alluded to, and I'll talk about a table that is kind of near and dear to the heart, and that is that in 2019, there was a study of the 10 U.S. metropolitan statistical areas by motor vehicle theft rate. Long introduction there. But on number 6 on the list is Topeka, Kansas, with 1,293 stolen vehicles. So we actually made the top 10 list just here in Kansas, and it happened to be Topeka. Some of the things we've been able to do with our license plate reader program that we can physically show in a statistical measure is that we've reduced the average recovery rate from what it was to minus 4 days. I'd have been impressed if we'd have reduced it 4 hours, but we reduced it by 4 days, which I thought was pretty compelling. We recently just finished with our auto crimes enforcement program. It was a 180-day pilot program, which combined a specific set of officers to respond to these license plate reader alerts and then to conduct proactive policing. Some of the more amazing things that they did is from February 2021 to February this year, they reduced auto theft in Wichita, Kansas from 239 stolen vehicles in that month to 161. I felt that was very, very significant. And in January, they reduced it from 268 to 228. So we're seeing great reductions with a combination of these specialized units and the usage of license plate readers. And I've got a couple of stories I'll tell. Of course, I could tell 100 of these because we document everything on an internal tracking log, which documents all of our statistics. And actually, the statistics you have from my written testimony, I've updated since I even wrote this, and it should say 15 months of tracking. And we have 316 stolen vehicles recovered, 112 license plates. Those are all separate from the stolen cars, and just over $3 million in vehicle recoveries with 325 arrests and 37 guns seized. And of course, a multitude of drugs of every kind. I'll start in with a quick story. A 911 call was received for an abduction auto theft from 2001 South Oliver on a blue BMW with a 1-year-old child in the vehicle. Witnesses and the victim stated a white Scion was used in concert with the auto theft, and the white Scion was identified using LPR technology as it was seen in the area of the auto theft at the time. The blue BMW was located a short ways down the street, and the child was not harmed, thankfully. Because of the associated vehicle identification from LPR data, officers were able to locate the Scion driver who provided the identity for the kidnapper / auto thief, who was apprehended a short time later. So again, that's a great story, and I've got many more. But I'll tell you this one last one because this is an incredible story as well. In January, officers used ALPR to locate a VW Passat that was taken in a residential robbery of an 82-year-old female. The victim stated 3 suspects forced their way into her home and knocked her to the ground, causing injury. The suspects took her purse, money, cell phone, and other items before leaving in her vehicle. Officers got a timely license plate reader alert at 13th and Hillside. The vehicle and 4 suspects were taken into custody without incident. The suspects were identified by detectives and confessed in implicating each other, implicating the other 3 suspects. They were all booked for robbery and later charged for ag robbery, felony theft, and battery. So that's a pretty amazing and incredible story. Some of the concerns, of course, that are brought up in with license plate reader technology as it stands related to the Cora issue is that commercial data collection. Obviously, we don't want businesses for any commercial purpose collecting data and using the police department as their tool for collecting data on their customers. Core requests for data in general. We don't want victims of domestic violence having their stalker. And then, of course, the physical locations. I mean, if certainly we opened the physical locations to the public and told them exactly where they were, one of 2 things is going to occur. One, the suspect of any major crime is going to drive around the area and pass some area that's not going to be governed by a license plate reader, or you're going to have a lot of shovels out there bashing license plate readers around the city. One thing I did forget to mention when I was talking about the stats is we've solved at least 6 homicides in the city, and that's 6 already with the use of license plate reader technology. And this is our particular video we started with in no point significant. Some of the pros is that they're force multipliers. Obviously, there's more of them out there that are constantly out there working than we possibly could, and they're collecting objective evidence. They're not looking for a skin color or a particular kind of race. They're looking for a plate, a vehicle description, and there aren't any live feeds out there. When I talk about concerns in our community, they just really aren't there. And I know that because I've gone to many district advisory board meetings, neighborhood associations, and HOAs, and we do a lot of press releases to really stay in front of this and be transparent. And I really don't have a whole lot of questions from the community other than how do we get one of these in our HOA? So we've had multiple HOAs that have contacted us and businesses who have now purchased their own license plate reader for their community, and they have worked. I know I can tell you within 2 weeks of a neighborhood purchasing a license plate reader for their HOA, we were able to solve a serial burglary by catching the suspect using LPR technology. It was a pretty amazing deal. When I'm out talking with HOAs and neighborhood associations, one of the things that I always make sure I mention is these stats, and it always blows people away that we've been able to do some of the things that we've done. And we certainly couldn't have done it without license plate reader technology. I think that's all I have, and I will certainly stand for questions from the committee.
Thank you. Committee, we have written proponent testimony, again, from the League and the Highway Patrol. Any other proponents? Okay, questions for any of the proponents? Representative Wheeler?
Thank you, Mr. Chair, and perhaps Mr. Klump, it might be the most convenient. I just want to make sure that these license plate readers are not the same thing or related to or kin to those darn things that read your speed license plate.
That is a good question, Representative Wheeler. I appreciate you asking that. No, these are not used for speed enforcement, red light enforcement, anything like that, any traffic enforcement at all. Kansas does not have the laws in place that would even allow us to do that, because
I can assure you
Yeah.
Colorado does.
there are several states that do. Kansas does not.
I got a ticket when I was in my uncle's funeral procession, probably going 10 miles an hour. Thank you, sir.
You're welcome. Mr. Chairman, I forgot to mention when I was up here before, this passed the Senate 39-1. And one other
We
thing,
need to look really closely at it, is what you're saying.
yeah, that's right. So I expect the House to beat that percentage, is what I'm saying. I'll also, I researched states that I could find that had any license plate reader statutes, and about half of them have Cora closure records. Well, it's not Cora there, but open records closure. And that includes Nebraska and Oklahoma in our border states. Colorado, I couldn't find whether they did or didn't.
Representative Carmichael with a question.
Thank you, Mr. Chair. Perhaps more than one with your leave. Lieutenant, I can't remember whether you and I met when I was down there at the traffic division a year or two ago with the former chief. I can't remember.
We did, sir.
What was that? You were in uniform at the time, so I'm confused.
That was me.
Okay. As I recall, the city of Wichita was voluntarily, at least at that time, limiting the duration for which they retain this data. Is that correct, or do you keep these locations and tag numbers forever?
No, they're not kept forever, sir. We have two separate vendors. The one that we're using currently and mostly, it seems like, for some of the cases that I mentioned to you just now, that is a 30-day retention period, and it's on a rolling deletion. So at the 31st day, all that data is gone. And some cases, as you know, especially in a case of a shooting or a homicide, we'd love to look back 6 months before that and have that data there. But there's no way to do that, and that retention period is actually put on by the vendor themselves. So we couldn't change it if we wanted to.
So would I be correct that you are able to perform your law enforcement functions by only retaining this data for 30 days as opposed to forever?
So yes, sir, we have been able to effectively perform law enforcement functions by retaining that data. We would certainly be a little more effective, I think, if we retained it a little bit longer. 30 days is a little short, but it is now in policy as we've gone through our third revision of policy 804 for the Wichita Police Department that I wrote. And it is now hard and fast in policy and through our vendor that we cannot collect any more than 30 days.
So if this committee saw fit to limit the time that this data is retained, what period of time would you, based on your expertise, believe would be a reasonable limitation?
That's a difficult question to answer, certainly because I think there would be other chiefs and other sheriffs who utilize LPR data in different ways than we do would be able to, they would want to weigh in on that as well. I personally, again, from my personal point of view, I would want to keep that data over a year, as I know that these cases go on and on and on, especially when you're talking about human trafficking specifically. Having worked in exploited and missing children's unit as a detective, I can tell you those cases very, very quickly spiral from one victim into 10 or more, and then they start going in a 1 to 2, sometimes 5-year look back. And I'm not suggesting that we need a 5-year look back on license plate reader technology. I can't even tell you a time where we have used any license plate data whatsoever and having that long of a look back. But I do know that it would certainly be nice to have it longer than 30 days for sure.
I can appreciate the circumstance, and I can also appreciate you can only speak for yourself. I do also have a question or two for Mr. Klump, with your permission, Mr. Chair. Mr. Klump, as you are approaching, part of the reason that I asked the question of the lieutenant is, under this statutory scheme, if I were representing someone who believed that their spouse had been dissipating the marital assets for a continued, for a period of time, that they had been perhaps spending a lot of time over at their girlfriends and buying nice gifts and so on. So now we're in a domestic case, and I want to find out where the husband has been. I think under this law, so long as the judge thinks it's within the scope of discovery, I would be able to get all of the records about wherever Representative Wheeler or maybe even myself had been for the last year, 2, 3 years. Is that the way this would work?
Well, I'm not an attorney. I am Ed Klump, by the way.
Yes, you are.
I'm not an attorney, so I can't answer that with certainty, but I have been told that the way this is structured, it's not closing the record. It's merely limiting the access to it, and so that would make it subject to court orders.
Well, I'm concerned about how long we retain this data. Okay, and I can imagine, as Lieutenant points out, it would be nice to be able to look back 5 years from now and figure out whether the suspect was at the location involved 5 years ago. I can see the value in that, but I also have to counterbalance that with the concept of privacy. And by the way, I did a Cora request for my own tag number locations at the Wichita Police Department. Informally, I was told they didn't have any hits on me, so I think I'm okay so far. But I'm concerned, though, about how long we retain this data, particularly in circumstances where it's available to private litigants who, as we're often accused of, like to go on fishing expeditions. Can you give us any time period that you might recommend that would be a reasonable time to retain the records for law enforcement purposes, but at the same time give me some assurance that I don't have to worry that forever my wife's attorney might find that I was at Baby Dolls one night?
So let me precede my answer with that, in that we intentionally structured this bill around the open records request and not into those issues, because we think those issues deserve a lot more time, discussion, and research to look at that. But I will say that I would agree with Officer Slaughter that 30 days is too short for many of our cases. I mean, many of our violent crimes, drive-by shootings, homicides, and things like that, even rape cases and other crimes, suspects are developed over a significant period of time, and many times it's going to be over 30 days. And sometimes you get a lead on a particular individual, and to be able to go back, say 6 months later, and look at that data and say, was this person in the area of that crime? If we happen to have a license plate reader in that area, would have great value. And so it's just difficult without more research and without more survey of our membership of our associations on what they would prefer and what they think is a reasonable time period, and then have to make our case on that if that were to be a part of legislation.
Part of the reason that I ask is I assured my former chief that I would leave this alone for a year or so that y'all would have time to use it, and then we could come back and look at these issues. And so here we are with a bill, and now I'm looking to say perhaps we ought to do some limitations. You're getting ready to say something.
And I'll say, from our association's perspective, we would be more than happy to have that discussion. We're trying to get this addressed right now so that we can get the issue of the placement on the highways taken care of. And we would be more than happy to come back and have discussions about those other things surrounding the issue.
And finally, with the chair's permission, during the course of perhaps it was your testimony, you indicated, or maybe as Lieutenant Slaughter indicated, that one of the things that we'd want to prevent is commercial entities from requesting this data. But as I look at the statute or the bill that I have in front of me here, there's nothing here that prohibits the vendor from selling that information, or for that matter, the police department funding some new equipment by selling that information to private entities. Is there any prohibition that you're aware of, either in this bill or somewhere else, that would stop that from happening?
I'm not aware of any statutory provision that would do that. I think most of the agencies I've spoken to that where we've talked about that, they've all said that that's part of their contractual agreement with whoever they have running, they lease their systems or buy it from, is that is not subject to distribution by the company.
But that's only by virtue of the contract that the individual agency, and by the way, I don't have any problem with the Wichita Police Department on this, but I don't remember how many hundred agencies there are in Kansas, but I'm not sure they all follow the same good best practices that the Wichita Department is following. And that's why I'm asking,
Right.
maybe now is the time to do something.
Well, I mean, and that's
Rhetorical
a
question.
decision you all need to make, but
Sure.
we have 10 days left, so.
Yeah, let's put this bill off till next year. Thank you, Mr. Chair.
Or let's pass this one and come back and visit that next year.
Any other questions for the proponents? Any neutral conferees? Thanks, Ed. Any neutral conferees? We have one written opponent from the Kansas Coalition for Open Government. Any other opponents? Not seeing any. Closing the hearing on Senate Bill 434 and opening the hearing on Senate Bill 435. Welcome back, Natalie.
Thank you, Mr. Chairman. Senate Bill 435 would expand law enforcement officers' jurisdiction to include situations when an illegal act is observed that the officer reasonably believes will jeopardize the safety of any person without immediate action. Section 1 amends KSA 2224-01A. That's the criminal procedure statute that confirms law enforcement officer jurisdiction. The bill makes the language more consistent throughout each subsection. This is a pretty old statute, so it's being updated here. So it makes it more consistent for the different types of law enforcement officers, and then it consolidates the provisions that apply to all officers into a new subsection H. All law enforcement officers not otherwise provided statewide jurisdiction would be able to exercise the powers and authority of law enforcement officers anywhere when a request for assistance has been made by law enforcement officers from the area for which assistance is requested, in fresh pursuit of a person, transporting persons in custody to an appropriate facility, wherever that facility may be located, and investigating a crime that occurred within the law enforcement officer's jurisdiction with appropriate notification to, in coordination with the local law enforcement agency with jurisdiction where that investigation is going to be conducted. New subsection I provides that in addition to the jurisdictional authority provided in this section and any other provision of law, all law enforcement officers can exercise the powers and authority of law enforcement officers when outside their described jurisdiction and when an illegal act is observed that the law enforcement officer reasonably believes will jeopardize the safety of any person without immediate action subject to those specified conditions. Section 2 amends KSA 726146. That's the statute that concerns school security officers and campus police officers. This bill removes subsection D there because those same provisions are going to be in KSA 2224-01A. And I can take any questions.
Questions for Natalie? Okay, thank you. And with proponents, and once again, Ed Klump.
Thank you, Mr. Chairman, committee members, Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. Got my tongue tied there. This bill is to address several inconsistencies and gaps in the current jurisdiction statute, which is KSA 22-2401A. Like Natalie said, this statute's been around for a while. It's been amended several times. This statute deals with only local agencies. It does not deal with state agencies. Each state agency has their own statute that authorizes them to have officers and in some cases restricts their jurisdiction. So this does not address any state agencies. This is being brought up now because we are having cases occur where because of the wording in this statute, we're having evidence that's been collected thrown out of court, and we're having arrests dismissed as being improper because of the jurisdiction issue. And so that's why we're bringing this. And you won't find that in published case law. These are usually court rulings on evidence and arrest that happen, within the court. So in the statute, there's 3 areas generally mentioned throughout it where statute extends jurisdiction outside the geographic boundaries of the local law enforcement agency. One of those is that in any place another law enforcement agency requests their assistance. The second was when in fresh pursuit. And the third one is when transporting a person in their custody. However, none of the listed agencies in this, and there's a list of agencies that are covered in the bill: county law enforcement, city law enforcement, tribal law enforcement, university police, campus police, adjutant general law enforcement, and the horse thief reservoir police. So those are the ones that are listed in statute, and those have been added over time. So for example, county agencies and city agencies, tribal law enforcement, and university police are not granted jurisdiction when transporting persons in custody, but the others are. Campus police are not allowed to assist another law enforcement agency even upon their request. And tribal police and university police do not have the authority of fresh pursuit. And so we don't think any of those were intentional. We think it's just the way this statute has developed over time, that people would come in, want to be added, and they say, well, we think we need this, and so I add it there, but they don't add it anywhere else. And so the structure of this is to take all of those things, remove them from the individual section or subsections for each agency type, put them in one place so they apply to everybody uniformly. And keep in mind, all of these agencies are certified law enforcement agencies or certified law enforcement officers through CPOST with the required training and everything. So you find those 3 extended jurisdictions now on page 6, lines 24 through 31. Another thing this bill does is create a new extension of jurisdiction covering when officers are investigating a crime occurring within their jurisdiction, but that investigation takes them outside their jurisdiction. And this is kind of a new problem that's come up, and we had a couple of cases in the Kansas City metro area that courts threw out some evidence. In one of those cases, the victim of a crime was in not their hometown where the crime occurred. They went to their hometown, tried to report it. And of course, the agency there says you need to report it where it occurred. So they went back to the other agency and reported it. So now both agencies are aware of this crime and aware that an investigation is going on. Well, the investigating officer from the jurisdiction where the crime occurred actually went over to the city where the victim lived to interview a person of interest, thinking it was probably a witness, as I understand it. And in the process learns not only is this the suspect, but the person has evidence of the crime, which the officer seized. And the court threw that out because the officer was outside his jurisdiction under the statute when that property was seized. So these are the kind of things that we're running into. We're seeing more and more challenges based on these. So we put a provision in this on page 6, lines 32, 35, that provides that the officer's jurisdiction extends when they're out of their jurisdiction doing an investigation, provided that they notify that other jurisdiction that they are there conducting an investigation. We don't want to go in blindly and they have nothing to do. And that's very important for our safety and everybody's safety, because frequently, I shouldn't say frequently, sometimes we have people who aren't sure this is an officer, especially if it's an investigator out of uniform. And so what do? They call 911. Hey, I got somebody at my door saying they're a police officer. Are they? Well, we want that 911 operator to be able to say, yes, they are legitimate. And so that provision is in there. The other one is a new provision that's found in subsection I on page 6, lines 36 through page 7, line 9. And this is one that is designed to address concerns with liability and public safety. We frequently have officers who are traveling outside of the jurisdiction, going to training, going to conduct investigations, coming back or going to the state hospitals or transporting people in our custody. And they come across activity that is reasonable to believe is putting somebody at risk if they don't take immediate action. Many times they're in uniform. Many times they're even in a marked car. And the last thing we want is for them to just ignore it and drive by or just sit there and watch it unfold. But under the current law, they have no jurisdiction in that case when they're outside of their area. So we crafted a very narrow exception that extends their jurisdiction, that only applies when the officer is properly identified as an officer, and they're either traveling in an on-duty capacity or in a law enforcement vehicle. And then they have to observe what they reasonably believe is an illegal activity and that a person's safety may be jeopardized without immediate action. And then we set out several things they have to do. They have to notify the jurisdiction of authority as soon as they can. They have to remain there until officers from that jurisdiction arrive. They have to cooperate with those officers in the investigation. They have to report it back to their own agency that they've taken an action outside of the jurisdiction. And then we added one other provision that allows a local jurisdiction, if they choose to put further restrictions on their own employees when they're outside of the jurisdiction. So we leave control of that in the hands of the officer's agency. So here's the scenarios that can happen. We're driving back from someplace and maybe alongside the road, there's a couple arguing and starting to have a physical altercation in what appears to be a domestic violence situation. And we certainly want these officers to intervene. And quite frankly, they do today. They don't drive by something like that. That's the way we're wired. And if that goes bad, if things go bad or you have to use any level of force and somebody files a suit, one of the first things that's going to come up is you didn't even have authority to be there. Why were you even engaging in this? You didn't have jurisdiction. And so that's one thing it's wanting to address. But the most important thing is the public safety factor. If, you know, we need all the help we can get across this state with our law enforcement presence. And if we have a trained officer in these capacities on duty in a vehicle, identifiable, and they can stop and intervene in a situation like that, we would expect them to do so. And we want them to do so with the full authority of the law. And that's what this bill does. So we believe this bill creates consistency on these jurisdictional issues, fills gaps in the current law, and we encourage you to pass it favorably. And I'll stand for questions.
Questions for Ed? Representative Long?
Thank you, Mr. Chairman. Ed, the way this bill's written, you're talking about on-duty police officers transferring prisoners out of their jurisdiction. What about off-duty officers? In other words, excuse me, we see an off-duty police officer in plain clothes in a county next to his, and he walks into a convenience store, and this guy's got a gun out pointed at the gal running it, and he takes action. Is this going to be part of that? He wasn't on duty.
This bill does not cover it the way it's written today, and that was by design because we wanted to start this out at a more narrow scope because there is concern. We don't want officers from one jurisdiction going to the other jurisdiction just to, you know, write a traffic ticket or whatever may come up. We want to keep this narrow. Off-duty officers are a little bit different, and we just chose not to expand it that far in our bill. I will note, you talked about the on-duty, and if none of you caught it, the conditions here are identifiable as a police officer. So that doesn't mean in uniform. It can be in uniform or I properly identify myself. But it also requires them to be either in an on-duty capacity or in a law enforcement vehicle. And that's very important because in current labor laws, when you're traveling outside of your jurisdiction, like going to training, only the driver is considered on duty. The other people in the car, even though they're a passenger in the law enforcement vehicle, are not considered to be on duty for pay purposes. And so we wanted to cover both of those, because if you have a vehicle with 2, 3, or 4 officers in it, we want them to all be covered. And so that was by design that we kind of put that in there, that wording in there. So that on duty is kind of a tricky topic that we need to work around.
So the off-duty portion of this, in the convenience store a county or two away, and the off-duty guy has a service weapon or a weapon, and he uses it against the perpetrator. It's more like a regular citizen at that point.
They probably are acting more as a citizen.
Okay. Thank you, Mr. Chairman.
Representative Wheeler.
Just want to clarify, you said the officer is on duty and in a law enforcement vehicle. Did I understand? There's something.
And you need one of the two others, either on duty or in a law enforcement vehicle.
And when he gets out of that vehicle to do whatever he needs to do, does he lose the status?
I don't believe.
I think, does it say traveling in? Because I'm trying to find the proper provision.
See if Natalie can find it faster than I can.
I think it says traveling in. Line 42.
Traveling in a law enforcement vehicle to or from work, or traveling to a training or law enforcement function outside the jurisdiction.
Okay, and identifiable as a law enforcement officer can be means other than a uniform.
It can mean identifying him in any manner. In other words, as long as I have my badge, my ID, and I identify myself as a police officer.
Any other questions? Okay, thank you.
Thank you, committee.
Next, we have Dan Carney.
Thank you. Excuse me. My name is Dan Carney. I'm the Director of Safety and Security for the Blue Valley School District, where I've worked for about 10 years. I retired from the Overland Park Police Department after 26 there. My scope on this is more narrow, and I think therefore I'll be pretty concise and maybe just add a little bit of color to what we're talking about. I have a police department, campus police department, Blue Valley, with 11 members, and they are all trained and commissioned police officers in a police department. Collectively, they have over 200 years of law enforcement experience. So they're very good. Let's put it that way. When I was with Overland Park, I remember the mutual aid legislation. I remember we were all very excited about it because it kind of cleared up some pretty murky water about what we could do if we were asked to come to another city, Leawood, Lenexa, the ones around us, to help. And it cleared that up, and we were all very happy about that. So I go to work for Blue Valley, and we've got a police department here, and I mistakenly assumed the same thing applies to us, only to learn later that it does not. And so there have been things along the way that have been minor things, like a homecoming parade, where our officers might get asked to help the city department to block some intersections for them. And I have to say no, because we're not empowered. More recently, this isn't in what I wrote here, but more recently, when Officer Mosier was killed in Overland Park, the Major Jenkins over patrol asked if I could provide some officers to ride double with some of their officers during the funeral, because so many officers would be attending the funeral. And again, I had to say, no, we would not be empowered. I can't put them in that position to do that. But I also think about scenarios where maybe there would be a severe weather event tornado or an area of the city might be damaged, and they might ask for our help just to come and help secure the perimeter or something like that. I don't foresee this for us being an everyday event or really very common at all, but just if our help were needed, we have a couple of marked cars, if one of my officers is driving back from school and comes upon an accident, they'd like to stop and help. They'd like to turn on the lights and keep the traffic off the back of that accident until the city officers arrive. So my purpose really in all of this and appreciating these changes is that we really just want to be better partners to the cities that we work in, and they are excellent partners to us, and we just want to be there for them in those extenuating circumstances where they need us. Thank you.
Any questions, committee? Okay, thank you, sir. We also have proponent written testimony from the league. Any other proponents? Are there any neutrals or opponents? Seeing any, we'll close the hearing on Senate Bill 435. Committee, give me 1 minute. Okay, committee, we're going to work House Bill 2556, which we have worked before turnaround. This made it out of committee, went below the line. It got blessed and got sent back to us. So it's here again to send back out to the body. So I'll have Natalie remind you what this bill does.
Mr. Chairman, House Bill 2556 would prohibit the denial of a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. In committee, you guys added the contents of House Bill 2557, which does the same thing for petitions for expungement for juvenile adjudications.
Any questions for Natalie? Are there any amendments? Not, is there a motion concerning 2556? Representative Curtis?
Thank you, Mr. Chairman. I move that we pass out House Bill 2556 favorable.
Is there a second? Was that Representative Keither?
It is.
Very good. Good to hear you. Any discussion?
I'm here.
Yeah. Yes, Representative Curtis.
Thank you, Mr. Chairman. So just to bring the committee up to speed, we had 3 expungement bills. These 2 got bundled, and then 2575, which allowed for an automated process for expungement for not guilties, dismissals, and diversions. Unfortunately, got left behind the line. We had contemplated on amending it to this bill, but without the assurances of amending 2575 into the bill that we have currently getting above the line. I know that the Clean Slate Coalition would rather save some of the work on expungement rather than chance losing all of it. So anyway, I just wanted to bring you up to speed on where we're at with those 2, and hopefully the Clean Slate Coalition, maybe some of them are listening, don't lose your hope and faith on coming back next year, and hopefully we'll be more successful with that measure next year. So thank you.
And I would just add, I think this is a good first step. We sent the bill last year to Judicial Council. They looked at it. They made a couple of recommendations and then gave you some guidance that you used to come up with the bill that unfortunately is not moving forward. But I do think, we've had a couple of years of talking about this, and this hopefully moves us in that direction, and we'll just see what the future holds. Representative Carmichael.
Thank you, Mr. Chair. First, procedurally, I want to make sure that when we say 2556, it's as we've previously amended it so that it includes both bills. Are we covered on that clean, or do we need to do something different?
Natalie.
Mr. Chairman, that's the understanding that I had of the motion. So
Okay, just want to make sure we're clear on that. Now, this is really difficult. because what's happening here is a package really of 3 bills that went through Judicial Council that were all really good ideas. One of them's being torpedoed for some reason. It's being torpedoed by people not in this room, I don't believe. We don't know who it is that's torpedoing the companion legislation, and we don't know why. And it's extremely disappointing to me to see as much time and effort has been put forth to try to modernize our expungement laws, including hearings by Judicial Council, and yet now it's just being thrown away, apparently because leadership won't let it above the line. Thank you, Mr. Chair.
Any further discussion? Representative Curtis, would you like to close?
Thank you, Mr. Chair. Yes, I close.
For the motion, all in favor, say aye. Aye. All opposed, say no. Motion carries. The affirmative votes are Hoheisel, Carmichael, Heiberger, and O'Hobson. That is it for today, committee, and that's it for the week. We're not, I know, it's crazy, but we're not going to be back in committee until Monday. Now, for Monday, we will have a bill hearing, likely to last most of the day. But just in the event we have time, and in the event some of these bills move forward or have amendments moving forward, I want to get them on your radar. So, 2495 for like the 10th day in a row will be on the list of potential bills if they come up with an amendment. 2697, which is the KDAD's mobile competency bill. I don't know where they're at on amendments, but maybe by Monday's a long way away, so I want that to be on your list. And then this one, 2538. That was the bill that the prosecutors brought. Let me find exactly what it said. It had to do with preliminary hearings and the timing to do them, and also the use of two-way audio-visual communication in those preliminary hearings. I am contemplating separating that and just bringing forward the two-way audio-visual communication piece. And if I were to do that, I would put it in 2447, which is a blessed shell we have. So I just want to lay out what I'm thinking in the event that I keep thinking through that and decide I want to do that on Monday. But I wanted to tell you that's where I'm kind of leaning, and we'll see how I feel on Monday. But again, it would be to take the portion of the two-way audio-visual communication, only that piece, not anything to do with the time requirements, and putting that into another House bill. But we'll talk about it between now and then. If you have strong feelings in either way, let me know. But I want that to be on your radar, something we may consider at some point in time. That's all I have at this point. Anyone else have anything? Okay, not, thank you. We're adjourned.